245 people were charged with murder. 245 times, the same lawyer stood up in court to defend them. And 245 times, every single one of them walked free. Not one loss, not one conviction that stuck. A record so extraordinary that Guinness World Records gave him an official title, the most successful lawyer who has ever lived. Most people have never heard his name. But by the end of this video, you're going to understand something about how trials actually work that most lawyers spend their entire careers trying to figure out, and never fully do. Before we get into how he did it, you need to understand just how statistically insane this record actually is. Even the most legendary American defense attorneys, the ones you've actually heard of, measure their careers in dozens of major wins. A handful of high-profile acquittals is enough to make someone famous for life. This man did it 245 times in a row, in murder cases specifically, the hardest category of case there is to win, because juries walk in already assuming the worst. His name was Sir Lionel Luckhoo. Born in Guyana in South America, he practiced law from 1940 to 1985. And the method he used wasn't luck, and it wasn't some legal loophole he exploited over and over. It was a specific, repeatable courtroom philosophy, one you can actually learn from, whether or not you'll ever set foot in a courtroom yourself. Here's the first thing that separates Luckhoo's approach from the popular image of a great trial lawyer. Most people picture a courtroom genius who thinks brilliantly on his feet, delivering dramatic speeches that sway a jury in the moment. That's not what built this record. What built it was obsessive, exhaustive preparation before the trial ever started. Reports on his method describe him tearing apart the prosecution's evidence piece by piece, looking for the smallest inconsistency, the weakest link in the chain, long before he ever stood up in front of a jury. This connects to something fundamental in criminal law that we've talked about before on this channel. The prosecution has to prove guilt beyond a reasonable doubt. That's an extremely high bar. And the way you consistently clear that bar as a defense attorney isn't by being the most charismatic person in the room. It's by finding the one weak point in the prosecution's case and building your entire defense around it. Here's where it gets genuinely fascinating, because Luckhoo left behind a detailed account of exactly how he approached a jury psychologically, and it's almost nothing like what television teaches you about courtroom drama. His method, as described in his own biography, was to scan the jury during his opening and identify two specific people. One juror who seemed to be nodding along, agreeing with him, and one juror who looked away, unconvinced. His strategy was deliberate. Speak first and most directly to the juror who was already open to persuasion. Win that person over completely. Then and only then, turn his full attention to the skeptical juror, treating that one person as if the entire case depended on convincing them alone. Why does this work? Because juries don't deliberate as a single mind. They deliberate as a group of individuals who influence each other. If you win over the most persuadable person in the room first, you don't just get one vote, you get an ally who helps convince the others once deliberation starts. This is basic social psychology applied with surgical precision inside a courtroom. Now, here's something important for us to be honest about, because the full picture is more nuanced than the headline number suggests. According to his own record as documented by Guinness, not every one of those 245 cases ended in a not guilty verdict at the original trial. In a handful of instances, his clients were actually found guilty by a jury, but Luckhoo secured their acquittal later on appeal. This detail actually makes the record more impressive in one specific sense. It shows he wasn't just gifted at swaying juries in the room. He was equally skilled at finding legal and procedural errors after a conviction, the kind of technical, detail-oriented work that has nothing to do with charisma at all. This tells us something important about what winning actually means in law. It's not always about one dramatic moment in a courtroom. Sometimes the win comes from something as unglamorous as rereading a trial transcript looking for a single mistake a judge made months earlier. Here's a detail that surprises almost everyone who learns about this case. Luckhoo didn't start out planning to be a lawyer at all. He originally trained in medicine in England before switching to law, reportedly because he found surgical procedures too difficult to stomach. And later in life, after retiring from law in 1985 with his record fully intact, he walked away from the legal profession entirely and became a Christian evangelist, spending his final years focused on religious ministry rather than the courtroom that made him famous. A man who spent 45 years methodically dismantling prosecution cases, one juror at a time, chose to spend his final chapter doing something completely unrelated to law. That's not something you'll find in most legal textbooks about him, but it tells you this wasn't a man defined purely by winning. It was a man who happened to be extraordinarily good at one specific skill for a specific period of his life. So what actually made this record possible? Strip away the mythology, and it comes down to two things: preparation intense enough to find weaknesses nobody else would catch, and a genuine understanding that a jury isn't one mind to convince. It's 12 individual people, each persuadable in a slightly different way. That's not magic. That's not a trick. That's a method, one that happens to be almost impossible to execute at this level, which is exactly why nobody has matched this record since. You'll probably never be a defense attorney, and hopefully you'll never need one. But there's something in this story that applies far beyond a courtroom. Luckhoo's entire method was built on a simple truth. You don't change someone's mind by overwhelming everyone in the room at once. You find the person most open to hearing you, earn their trust completely, and let that trust do work you could never do alone. That's not just a legal strategy. That's how persuasion actually works in a courtroom, in a negotiation, or in a disagreement with someone you care about. If stories like this, the ones buried in legal history that completely change how you see the justice system, are what you come here for, subscribe. This channel breaks one down every single week. And if you want to see what happens on the complete opposite end of this spectrum, a case where the defense strategy fell apart in front of everyone watching, I covered that case right here.